Maybe they'll,
for you to hear better?
That's better.
That better? Okay, all right, I'll just keep my mic on so we can hear, so. And one of the reasons that I wanted to do a work session is because this thing is so long, and I actually do have the main areas that we changed. If you guys want me to kind of skim through those so that if you, I don't know if y'all had any specific questions, but I'll just go through the parts that we did change and see if there's any questions about that. John Grubbs is on here with us from MTAS. He is our HR specialist. What's your title, John?
I'm an HR consultant.
HR consultant, but we're going to call him a specialist, okay? John, talk and see if everybody can hear you.
Did everybody hear me?
It needs to be louder.
Okay, Courtney, which one is this coming out of? This?
Yes.
Okay, now talk again, John.
All right, how about this?
I still can't, but it's better.
What?
It'd be on
There ought to be like a little knob on it or something.
Maybe all the way up.
Try again.
Okay, say something again, John.
Something again. How's that?
I feel like we're all the way up now.
Are we all the way up?
Yeah.
And that one's not working, Courtney, is that right?
Right.
Okay, all right. Well, I might have to be your interpreter if you do,
Yeah.
kind of, if they have questions and tell what needs to be talked about.
Not
So-
a problem.
Okay. All right, so really, and this is, this is pretty common, I think, for a lot of municipalities. That's why MTAS comes and helps us with what needs to be done. So in section 1 under general provisions, there were some changes here. The purpose of the following policies to establish a high degree of understanding and cooperation with the town employees.
You put your mic over here, so.
Oh, gosh.
No, that's all right. Don't worry about it.
Okay.
I can get it right here and here.
Okay. Can you hear now?
Yeah.
I can put mine on the speaker if you want.
Oh, put yours too. Maybe both of them. I don't know. Okay,
You
there.
tried William's speaker, just using the laptop. Sometimes the laptop might be pretty loud.
The laptop speaker? Okay.
All right.
Hey, John,
I'm sitting in front, I can hear.
now say something again.
Okay, how's this?
That's better, isn't it?
Better turn that up a
Good
little bit
idea.
too if you want.
Okay.
There you
let's
go.
see.
Go down
Yeah.
there to that speaker.
Yeah, okay, that is better. Oops. There, okay. Now, all right. I don't know if there was much in here. This is just general information. The purpose of the following policies is to establish a high degree of understanding. No, not at all. And cooperation among the town employees, which comes from the application of good procedures and personnel administration. I mean, this is just an introduction. I don't think, John, there's not a lot of meat in that we need to really talk about, is there?
That's correct, there's not. Now, the paragraph below that, we kind of added and expanded over the last several years to incorporate all of the protections in one paragraph, and then under that, the one with the asterisk explains what can be expected when an employee thinks they may have First Amendment protections as an employee. And that's pretty much it. This first section, general provisions, is kind of a high-level overview of rights and protections and so forth.
Okay, if you guys have anything, and if you've underlined anything on a section that you have questions about,
Before I forget it,
okay,
every document that comes to us should have page numbers on it. You try to find something in here, it's darn near impossible.
I know, our final copy will.
Thank you.
Okay,
Question
okay,
on A, purpose and introduction. I don't understand this part. Down in about middle of the bold print there, and it is the policy of the town. But go on down and it says, exercise of free speech made as a citizen as a matter of public concern, refusal to participate in or remain silent about illegal activities.
That's just that's referring to anti-retaliation laws. So it makes it illegal to fire somebody for reporting illegal activity, or makes it illegal to fire somebody because they supported somebody who's making, for instance, a sexual harassment complaint. That's what all that's referring to. That's just a concept in anti-retaliation laws.
Okay, but now, let me understand, okay? If I made sexual harassment against some person,
Okay.
male or female, and Lance knew about it
Yeah.
and didn't report it, so there's no retaliation against him, is that what you're saying?
No. This says refusal to participate in or remain silent about.
So he
So,
remained silent, that's what I'm saying.
no, we're saying it's the policy of the town not to discriminate and not to punish people for refusing to remain silent about illegal activity or sexual harassment.
You're saying the reverse of the way I'm reading it, but okay.
Right. It's a very long, it's a
As
run-on
long as
sentence.
you know what they're talking
Yeah.
about, it's all right.
It's a run-on sentence and nobody's going to read it anyway, so.
Yeah, and it's right out of the verbiage that's, y'all didn't make up.
That's why we have
Yes,
laws.
yeah, that's right, yeah, okay. All right, anything else there? So, and I am trying to go just to the things that were changed, okay? I mean, I know, yeah, yeah. In red, with some policies going on to B, under coverage, go to coverage. And it says, some policies apply to all employees and officers of the town, including those placed in the exempted class above, such as policies related to discrimination and/or harassment, and policies required by state or federal law. Again, just some required verbiage, I think, there. Okay. I'm already over on section 3, under compensation. Okay. And I didn't have this in red, but we did do some changes here on this overtime pay. Is this where we put this, John?
H.
Under overtime pay, under H. It was not red on here, but I know we did change that, I think.
Yeah, I think that the only thing.
Okay, yeah.
Yeah. 1.5 times the employee's regular rate. Overtime work may also be paid with compensatory time at 1.5 times hours worked in accordance. I don't know that we made any substantive changes. We may have changed some of the wording.
Right. So basically what I desire to do at this point is to go away from the comp time, because I've been advised you start accumulating that over a period of time, and if they all came to you and said they wanted their comp time, it could be very costly, and best to just pay it out. And I haven't done a firm policy or anything on that, but if this gets passed, it says we also have, if it is best to use compensatory time, that we can, use whatever is needed here, but trying to go away from that. And my suggestion is to give them from January 1 of 2026 to the end of the year to try to cash out all their comp time that they have accumulated right now. And their max hours to have accumulated is 80. Yes. and we're keeping that at 80, and hope to better control it too by even, working with the department heads on the ones that can, and if they have to come in after hours during the week, 4 hours, then if the workload's not too heavy, then let's try to take 4 hours, again, before the end of the week instead of going into overtime. So
No, you're trying to do away with comp, right?
I'm trying to do away with comp.
And
I mean,
that's all departments.
all departments. When, there are going to be times where we, may have to use it, or if we see that it's, we've had, we're closer to the end of the year, and we need to, go back to use some compensatory time, but I really want to work with all the department heads on, being most efficient when we do have to use overtime or time and a half to be paid out, but,
Really, how much do we have to accrue as a percentage of the compensatory time?
What did you say, Arnold?
Okay, I got 80 hours, but that's gone. I'm up to, I'm like now, where we got up to 120 hours or something. Do you have to accrue somewhere in the funds?
Yes, yes.
Okay, and about how much is that accrual as a percentage?
We do it once a year at the end of June, and the auditors put it in the audit report, how much we have to come up with if everybody left.
My point being, we're paying for it one way or the other,
Right.
even if they don't take it this year.
right. And some of them have had some accrued for a long time when they made a lot less, so that was another reason to kind of look at that, so.
If I might jump in, one consideration is that if somebody earns compensatory time and they're making $15 an hour, and then they set on it for a few years, and then they're making $20 an hour, and then they quit, and you pay them out, which you have to with compensatory time, it costs more than, had you paid it when it was earned as overtime. So it's kind of like putting overtime on a credit card.
Okay, so I've gone all the way around. There was no other changes on that, on the rest of comp time or on-call time. So any questions?
Yeah, but
Okay,
not because it's new.
okay,
So somebody out of rank pay is what I'm looking at, section N under the same group.
okay,
So somebody can work for 2 months as a temporary work and not be paid the rate of that job? Is that what that's telling me?
Place here assigned, temporary work, and John, he's on N, out of rank pay, is that what you're talking about? Is that what you said? Okay. If you're assigned temporary work in a higher classification, you may receive additional compensation for any period in excess of 8 weeks retroactive to the date of the appointment. Out of rank pay, is it the discretion?
I'll just use Rex Dale, the way I read it as an example. He could replace you for 8 weeks because you're out sick.
Mm-hmm.
And, I mean, it's an extreme example, but he wouldn't be paid for it till after 8 weeks. Is that what this is saying? Not that
May
that would
receive
happen,
it.
but I'm talking
And it
about
says
a regular
may
employee.
receive additional compensation for any period in excess of 8 weeks, retroactive to the date of appointment.
That's what I don't understand.
It doesn't say anything about waiting 8 weeks.
No, it says-
It just says that you won't get paid more than 8 weeks, is how
I would take that as if I made $3 an hour and went to $8 an hour, I get paid the difference. That's the way I take it.
After 8 weeks?
No.
You wouldn't get paid, to me, it says in excess of 8 weeks, so you would only get that pay For 8 weeks.
Any period in excess of 8 weeks, retro.
It doesn't say anything about waiting a period of time to get paid that.
At a
You
rate
would just
pay
get
is.
compensated more if you've done a higher paying job, the way I take it.
Right. That's how I take it too.
Like if we had a supervisor out sick, which we did have when I came on board, and someone had to come in and take his place, so we did raise his wages because he was having to take on the supervisor position,
Okay,
so,
well, that's the
yeah.
way it should be.
Yeah, yes, yeah.
Okay, how do you read that?
We can get rid of the in excess of 8 weeks, since it makes it rather clear, and just say
Where
any
did you go?
period.
Sorry.
Right,
Point to me where
yeah.
you're talking about. A higher classification may receive additional compensation for any period in excess of 8 weeks retroactive to the date of the appointment.
Yeah, John's saying we can take out,
It just says if you work 9 weeks, like if you're the mayor or if you're the vice mayor and Lori's in a coma and for 9 weeks and you have mayor for 9 weeks, then you will get paid for that entire period of time. Now it says retroactive.
so basically it's saying the whole time.
Well,
Retroactive.
retroactive too means, because we don't always know how long you'll have to fill in for somebody, so it could be 7 weeks and then you won't get paid. Or it could be 8 weeks in one day, in which case it kicks in and you're retroactively paid for the last 8 weeks. So you wouldn't get paid up until you exceed that 8th week.
Just covering for somebody for 2 months with no additional benefit.
Right. Yeah, I mean,
That's the
obviously
way I
we
read
can
it.
change
Yeah,
that.
okay.
I don't think
Yeah.
that's right, but I mean, that's the way I read it.
Yeah. So
Yeah,
just change
Y'all
it.
gotta
If you
remember,
want
I'm
to-
an old union.
Yeah. We could,
Well,
Executive
eliminate the
also.
incentive of 8 weeks. You can set the period then, because it says out of rank pay is at the discretion of the town and available funding, so.
okay.
Yeah, just change it to whatever you want. In
Yeah.
excess of 1 week, in excess of 2 weeks.
Yeah,
Yeah, let's say, or maybe we say in excess of 2 weeks.
okay.
Okay.
So, okay,
I like that better.
That's
All
why
right.
we have the unions up north.
okay. All right.
I got called out as being James Earl Ray one time being in a union meeting in Chicago.
Okay,
These are all old-timey topics.
I got it.
yeah. And then on payroll deductions, there was a thing put in there about an employee who's garnished for more than one indebtedness within a 12-month period may be subject to disciplinary action in accordance with the Consumer Credit Protection Act, except for assignment of wages for spousal or child support. So, and then the next sentence on there was also, that's under payroll deductions. That was a change.
I can't
So-
imagine, I mean, that is obviously allowed under the law. I can't imagine a situation where you would punish somebody for getting their wages garnished. But, yeah, at
Okay,
least you have that in there.
It's nothing that was changed, but I think it's something important that we know. The salary of an employee whose position is reclassified and allocated to another class of a lower level, his salary can't be changed. That, I mean, that's good, I think.
and where are you on? What are you looking at right now?
Floor, on the same thing, pay rate for changes in status, reclassification.
Under M.
Under M,
Number 4.
on, oh, no, okay. This was reclassified,
In other words, the
Reclassified.
salary remains the same. And I mean, I think that's good, but I would never have known that.
right, okay.
So reclassification meaning the job goes away and they would get reclassified to something else, correct?
Right.
Not a demotion.
Yeah.
Or move to another department?
But if it's moved to different, yeah, so if you
Yeah.
move from finance to, I don't know, if we had an HR department, you know, your pay scale in HR may be lower than where you were in finance, but because you're used to getting paid, you know, $60,000 a year, you're not gonna get paid 55.
Gotcha.
You're still gonna get paid that 60, just
Yeah.
that we needed to move you over.
Okay, equal employment opportunity and the ADA, y'all, all of that, we,
May I
you know,
ask another question before we go
yeah,
further?
yeah.
And this, again, is a law, but I just didn't understand why they'd say that. I'm down, 1, 2, 3, down on the last page of this section.
Okay,
Any employee who is garnished more than one time within a 12 may be subject to disciplinary action. And then it goes on, except for assignments of wages or spousal support.
You
So
can't,
if
you aren't
you-
allowed to garnish those things.
Or,
You aren't allowed to garnish those
But
things.
you can, what this deals with, you can discipline an employee that is garnished, say, for failure to pay a credit card, more than once in a 12-month period, but you can't, discipline someone who has an assignment or garnishment of wages that comes into payroll because, spousal or child support. Every employer has to report new employees to the state of Tennessee so that they can chase down the spousal and child support. And TCA will not allow discipline in those circumstances. But you can discipline somebody if they keep, they didn't pay their Home Depot credit card, and somebody garnishes them. And they also didn't pay their Lowe's credit card, and somebody garnishes them a second time. You can discipline them for that because they're taking up resources in the finance department having to process those types of garnishments.
so it has to be a judge telling the city to deduct that. from his
No,
wages.
no. So if we were in the business of punishing employees who get wage garnishment, because it's a problem or something, it's not a problem, and we don't do that as far as I know, but say we're in the business of doing that. We can punish an employee for getting a garnishment as long as it's not a garnishment for child support or alimony, because we want the children and the ex-wife to get paid.
Okay, I'll still do that. Okay.
okay. Now we're to the American
Hello, you do, Arlo.
Americans with Disabilities.
Come on in, come on in.
What's going on, Mr. Elder? Miss Elder, Ellis, Brown?
Good to see you.
Okay, now we're down to the American with Disabilities Act. I mean, this is just law. I mean,
Ain't
and
nothing you can do.
so I don't know if anybody saw anything on there that
I
you,
read it, it's fine.
okay, all right. There's also the Pregnant Workers Fairness Act and Pump Acts.
I think we need to, maybe I missed it, but I think we need to use a qualified employee as a defined term and say what that is. Because we have qualified employee like 100 times in this one. I'm sure there's a statutory definition of it, but we should just put that in here.
Where are you seeing that?
Under C, pregnant workers or something.
Okay,
Gotta make a room.
okay. Okay,
Yeah, it says qualified employee like 20 times in here.
Okay.
So I think we should explain what what makes one a qualified employee
okay,
to fall into these protections.
okay. Okay. All right, A, C, D, okay. I'm on job announcements, recruitment by examination, types of examinations. The only change that we made in there were the pre-employment, post-offer drug test, that we have to define who our safety-sensitive employees are, because those are the only ones that we are allowed to do random drug tests on, correct, John?
And pre-employment, yes.
And pre-employment. So we are not to do pre-employment on anybody that is not safety sensitive. Is that what you're saying?
Correct.
Okay. So we are going to have a list of all of our safety sensitive employees, which includes people that answer the phone if there's a gas leak, okay? So we're working on that, so, okay.
I don't know if it's the wrong page number on here, but it's, you gotta go to.
Yeah, help him get,
Types of examinations.
Just round up that on the jacket.
types of examinations, and then talking about pre-employment, post-office drug test, there you go.
Okay. The only other thing that we did change from the old one, when it comes to, after the safety-sensitive applicants, I went on to the back on minimum age, and we've got, we added to the minimum age candidates for sworn police officer positions must be 21 years of age, and candidates for lifeguard positions must be 16 years of age at the time of appointment. And then just some highlights on the regular full-time employee and part-time. Part-time employee cannot exceed an average of 29 hours per week unless approved by the mayor. Anybody see anything in there that they have questions about? Okay. All the
Conditional employment. Do we have a probation period for employees? It's not spelled out, but it's offered conditional employment. Original hires.
yeah, I see. Non-employee passes all the tests. Employment is offered conditional.
Conditional hires typically when, when the mayor appoints somebody, maybe a temporary position. And if it's unclear, if it's not spelled out, for example, in your charter, where the mayor can just appoint temporarily, and that's conditional on the actual making somebody an employee. Let me look.
Shorten it up
In
for
your
me,
charter.
please. What I'm concerned about, we don't want to get in a situation where one person comes in and we give them 4 weeks and say they're not there, and another person comes in and we give them 12 weeks and then say not there. I mean, I think we should, if we're going to have conditional employment, we ought to specify what that probationary period is, so that
It's not this does not reference conditional in the sense of a probationary period.
what is your reference to?
And I was just looking through your charter, and I don't think it points directly to your charter, so we can eliminate the conditional hires.
Yeah, that's fine.
Yeah.
Just every employee is an at-will employee,
Yeah, I
and you can be
understand that.
cut loose anytime.
Yeah.
When you start getting into conditional hires or probationary periods, it makes people think that they have a higher status when they become when they're done with their probationary period. And that makes people think they have some sort of,
So you're recommending just eliminating the conditional?
yeah,
Okay,
just everybody's an
Conditional
at-will.
hire in that sense.
Yeah.
right here.
We're going to take that out, right?
Yep,
Okay.
Correct.
good.
okay. All right, y'all tell me if you see anything, and if you don't, I'm gonna go on down to work day, work week, which is P in that section.
See your page.
And the only change that was made on there was the work day, work week. And after a standard work week is scheduled between 8 a.m. Monday through 8 a.m. the following Monday. Sworn, non-exempt police positions and non-exempt fire positions may be designated differing work periods for the purposes of overtime calculation as provided by that code of the Fair Labor Standards Act. That is the only thing that we added, which was not included in there before. Then Meal periods, meal breaks, nothing there. Nepotism is, there's no change.
You gonna make people disclose their romantic relationships?
Where is that?
If a personal romantic or intimate relationship is established, so it also applies to personal relationships. But if a personal romantic or intimate relationship is established between two or more employees post-hire, it is the responsibility and obligation of the employees involved to disclose the existence of the relationship to the department head and mayor. That's kind of creepy. I don't know.
Just the personal part.
No, just, I mean, you think it's a good idea to force people to disclose when they start dating? Do we want to get into that, or?
It's just between two or more employees, right?
Right, that's
Not
right.
just-
Do you want to
Yeah,
know
if it's not,
people
I
are
mean, if it's
working
not a
together,
supervisor, if it's not a,
Yeah, I think it
Yeah.
should be for supervisory, maybe. Can we word it that way?
Sure, yeah.
okay.
But not
Yeah,
necessarily-
we'll just change this to romantic or intimate relationship is established between an employee and a supervisor.
Okay. Okay.
That'd be better.
That was not one we changed. Okay, under time reporting, time cards, time sheets must be signed by the employee and forwarded to the supervisor for review and approval. The employee's signature attests to the accuracy and completeness of the time card and sheet. We did make some changes there. No town employee is to punch the time clock in or out for another employee, and this and any deliberate documentation inaccuracies to time cards, time sheets will be considered falsification of records and documents and shall be a violation of town policy that will result in both employees receiving disciplinary action. And then we've got per chapter, we've got,
How many of
Not quoted.
the employees actually punch a clock?
a lot. Yeah,
A lot?
yeah. The majority,
Not all.
the majority, correct. Yeah.
Do you have like an app or something?
No, here at City Hall, we,
That's what I was
we,
getting ready
we,
to
we,
say.
we use these here, but, yeah,
The fire department has an app, I think,
Okay.
that they clock in and out of.
yeah, yeah.
We need,
I'm
the
working,
only reason I'm bringing this
I'm working
up,
on
I've
that.
heard
yeah,
how it goes.
yeah.
Hey, you heard it.
Yeah, yeah, no, that's in the budget, or working on being in the budget on some different clock-in
expensive
systems,
stuff.
it is, yeah,
Yeah.
so, that's,
Put a punch card or something.
Get them right.
yeah. Nothing different on leave policies, no changes, any questions on any of the leave policies?
Pretty boilerplate, isn't it?
And then under termination of an employee, on the backside, and I'm looking at my time here, guys. When an employee is terminated from the employment of the town, no accrued or unused vacation will be paid out when they're terminated. I am going to speed up just a little bit, so if you guys have questions about anything, let me know.
I'll shut up unless it's something really serious.
Okay, I'm all the way to military leave. Y'all catch up, make sure we're on the same page. Military leave. Y'all there?
Yes.
Okay. I don't know if anybody has anything to say about that. We went by laws.
It is what it is.
Yeah.
That's what they tell us to sell. Whenever,
Do we have any active military employees or reservists?
I don't know. We do, don't we? At public and at the,
Sure, we got some in the national government.
yeah.
Well, we won't fire somebody for being deployed somewhere.
Correct, yeah. Under leave of absence, under maintenance of benefits during leave of absence, we just put except, we added the term except for FMLA leave at the end of the first sentence. And that was another protective statement. All right, I want to make sure I'm turning the right page. Nothing under court leave, inclement weather, bereavement leave, that's where I'm just going to say these categories out loud. And then I'm going to be at section 6 under employee benefits. So everybody get there. Okay. All right. Under eligibility, generally employees are eligible for benefits when an employee work an average of 30 hours per week over the defined measurement period. I don't really remember why we put that in there, but anyway, it's under eligibility.
Well, the defined measurement period, the city would have to set its measurement period under the Affordable Care Act.
Right, okay,
So
okay. And then we have, okay, A, B, COBRA, death of an employee, we did add under the TCA code designation, all compensation due in accordance with the Tennessee Code annotated, designation of beneficiary wages and debts owed the deceased employee shall be paid except for such sums as by law must be paid to the surviving spouse. Under D, we added that sentence. Okay, I'm on safety, section 7. I'm under driving records. This is a no-brainer. It's prohibited for anyone to type or read a text message while driving. We did put that on there. That's under A, I think, at the bottom. And then there's B, the smoker and workers' comp, no changes there. Anything, Arno? Okay, and then under section 9, did I skip a section? I didn't, did I? I don't think so. Section 9 is the workplace violence and harassment. And John helped us just put in some verbiage that was missing there that is basically, Andre, anything on that?
Just getting to where we are.
Okay. I think I've got something backwards here. Maybe not. Is that on the back side of yours? Is that the next page? On yours? I think I've got I'm done. Okay. I think I'm a little bit out of order or something, but anyway, there's some substance abuse things in here and some specific policies. Random drug testing, again, for safety sensitive. And then more sexual harassment, employee obligation. Where are you? Are you here? Okay, I'm going faster than everybody else probably. Okay. Has anybody seen anything they want to ask about so far? I'm on section 10, political and public expression. Under political participation, we did put something here under that section A. That whole section is has been added. I don't know if y'all had any questions about that. They should act as a, wait. Well, y'all read it and see if y'all have any questions about that.
So has this always been our policy that no employees can run for office?
In the last several years, it has been.
Oh, that,
Like we couldn't run for, like somebody couldn't run for alderman.
Has that been the policy or just people that hadn't run? Because I do know that there was employees that was aldermen.
It was after that, David, I think they changed it. I don't know if it was in the personnel policy, but it was,
Okay.
So for an employee of a city to run for elected office for that city, it's okay if the city has passed an ordinance allowing it. Not all cities do. Not all cities want their employees, most actually do not allow their employees to run for elected office for that city or town that they're
Okay.
employed
That's
with.
that
Yeah.
some time ago.
yeah, some time ago. It was an ordinance, I think. So.
Okay.
No reason to second guess it in the personnel policy.
Okay.
So they can or they can't?
They can't,
Cannot.
Yeah. And then protected speech is down there too. Y'all kind of look at that and see if there's anything on protected speech.
That's just the legal standard for.
Okay. All right. Now we're on section 11. Nothing changed on travel policy, all of those miscellaneous policies. Nothing changed on personnel records or our ethics policy. But computer use and monitoring, basically, a lot of things changed in here. Technology's changed since, since the last policy and procedure manual was written, as we all know. So, this is just, I think, pretty normal verbiage for computer and social media policies in municipalities. So I don't know if anybody has any comments on that? Andre, are you getting ready to ask them? I mean, not, okay. Or no, that's really what I meant. Identity theft protection has been added in here. All of that is new. Okay, I'm on section 12. And the only thing that's changed is lay off, the reduction in force is a new section. A reduction in force may be determined as necessary. The Board of Mayor and Aldermen would be the ones that would be voting on that. And I already have that again. And then we've got the acknowledgement of receipt. It's pretty much all new, but we're making them acknowledge that they've received the copy of the personnel policy. And then on the back, the dismissal has several new things to it too. On the very back page. Y'all want to look at that? I kind of got faster. Do you have another question? Okay. Okay, well, ask it if you have one. Look, you've got
But I think
7
this is
minutes.
interesting. The town attorney is designated as the ethics office.
That's in every single municipal code.
I thought that was strange. I hope your ethics is
No,
good.
that's already in our municipal code. It's the same thing in every city.
Oh, gosh. Anything else? Bill or Lance or Arno or David, have you seen anything you need to ask questions about?
No, ma'am.
Okay,
We need to work on this dismissal, the disciplinary stuff. I'll work on this.
okay, okay,
I'm not real sure.
okay. John, you have any other words of wisdom for us before we let you off the hook?
Oh, no. I appreciate you letting me help out. I know there are, and this particular policy was kind of a mashup of the previous policy and some MTS models. So there may be some clumsily worded things in there that we still find.
Okay,
But I think things, looking through, I did add page numbers. So
okay, okay,
make sure that's
okay, all right. We have page numbers.
All right.
Yeah,
I
yeah.
see 64, that's the only one with the page number.
Well, we're getting page numbers. Yeah,
It's the last page, so that doesn't tell me anything.
okay. Okay. All right, well, I'm gonna let John off if no one has any questions for John, our MTS rep.
Thank you, John.
Thanks for
Thank you
thanks for
all.
hopping on.
I'm emailing this, I did highlight where the mention was for a qualified employee
Okay,
in there, and let me look, that was under the Pump Act, correct? Pregnant Workers Fairness and Pump Acts?
I think so, it was, yes, the
Oh, so
qualified
the
employee.
qualified employee is-
Yeah, yeah,
I'll take that, because
yeah, yeah,
a qualified person with a disability means an individual with a disability who has the requisite skills, experience, and education under ADA. We'll add that, essentially that same language to the Pump Act.
So it just means a pregnant person?
Yes.
Okay.
Well, hold on.
I'm sure there's a statutory definition, they just add that in there.
Yeah, can do that. And then the Pregnant Workers Fairness Act, qualified employee, and it's essentially the same statutory definition under Pregnant Workers Fairness Act as it is the ADA.
Okay.
So
okay,
I'll add that.
okay. We appreciate it.
All right, thank you all.
All right, have a great evening.
So he's making the changes.
Okay, let's get this out of my face.